Assistant Prosecutor.
Assistant Public Defender Plea Anderson with the mental health. Ellis is approaching. We submitted a plea form. This will be a plea for misdemeanor use with no objection to 7411.
Ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of use of cocaine. That is a misdemeanor punishable by up to 1 year incarceration, $2,000 fine plus court costs. Do you understand that?
Yes.
Ma'am, I also have to apprise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. Do you understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty.
All right, now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
All right. On August 17th, 2022, at the location of Holmes Road near Sweet Road, Ypsilanti Township, Washtenaw County, State of Michigan, did you have cocaine in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
Counsel, have I complied with the court rule?
Your Honor.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
7th at 10 a.m. before Judge Washington.
March 7th, 2024. At 9 a.m.
10 a.m.
10 a.m. before Judge Washington.
Thank you, Your Honor. And may I address our bond, please?
May counsel approach.
Yes.
I have children. I have children. What happened that you left court in April, but February? I've been in the hospital. I've been in all kind of stuff. I was incarcerated in another jail. I was in Wayne County Jail. That's why I didn't come back the first time. That's where that one got.
Okay, and the court's question was that there was a warrant that was issued for the defendant's failure to, she had a PR initially on this case. She didn't appear in April of 2023. She's not arraigned again by us until February of 2024. And my question was, where was she? And then I'm going to have a follow-up question.
Okay, yes, Your Honor. So in April, there is some notes that she contacted our office that she had COVID and wasn't able to appear. It looks like that's the date that the warrant was issued. She indicates to me that she was in the hospital some time and she was in a car accident and also in custody in the Wayne County Jail. Do you remember the dates or how long you were in Wayne County? I was in there 45 days.
How did she come back into custody?
I was in a car. I was in a car with someone and they was driving a stolen vehicle.
So you didn't turn yourself in, even after all that time. Motion for bond reduction denied. Bond will continue.
I didn't, honestly, it was all that time went past. I honestly forgot, Your Honor, about this charge. I will come. I don't mind coming to court for it. That's why I'm pleading guilty for it.
Take it up with Judge Washington. My decision is bond denied.
Thank you. Why would you sit there and have me plead guilty this week? You still gonna get the I got all these other court dates. My baby birthday is on the 20th. Why would you tell me I was getting out of here? You were getting out. I told you the judge has to make that decision. I'm sorry, guys. My baby about to be 2 years old and you playing with me like that, bro. Keep playing with me. Come on here, bro. You don't let my cry away. No. I'm about to miss my baby birthday, please. Don't touch me. Don't touch me.
And it's gone. Court calls the case, People versus Brent Graves. Court does call the case People versus Mark Rassman.
Morning, I'm Roderick K. Green, P3387. On behalf of Mr. Rossman, Your Honor, this
Good
is
morning, sir.
PCC. Good morning, Your Honor.
Sir, you need to face forward. Your name?
Mark Raven.
Your Honor, we just got discovered this morning and I have not had an opportunity to go over with my client. I'm asking for a 1 week adjournment for the PCC. Is that possible?
Yeah, it's possible, but okay.
The 15th, and I'd like to speak to bond if I may.
You may, go ahead.
Your Honor, my client has no criminal record whatsoever. The bond is extremely high, $100,000. He has no criminal record whatsoever. Works with his dad in construction. I'd ask for at least, Your Honor, a 20,000, 10% bond. I think that's reasonable.
Probable cause conference is adjourned out a week to the 15th. It's 9 a.m. Response from the people.
It's true that the defendant does have no criminal record. However, it is 100,000 with 10% privilege in this case. As the basis for that bond request was the allegations, and then he showed up to his ex-girlfriend's house. He left his TV outside the house because he knew he was on the way and she didn't want to see him. When he arrived, he started banging on the door. She opened it a little bit. He pushed his way in, put his hands around her neck, pushed her across the room and started yelling at her. This was in front of the victim's brother, who tried to separate the two and stop the defendant. The police were called, but the thing that's the most concerning is the statement that he made on his way out, where he told the police that for the shit I'm being charged with now, I should leave that shit out. It's concerning that the initial incident, initial violence and aggression was not enough for the defendant. We are concerned that if he's out, he would immediately return to the victim's residence, not just by his own actions, but that's what he said.
Well, Your Honor, the parties used to live together. This is a domestic violence case at best. She opened the door and he walked in. They used to live together. They lived together for 4 months and they had only parted a week before. So he's overcharged, number one, and the bond is extremely high.
It's extremely high, but also, I guess, once after this incident and he was arrested, he got to the jail and then started calling the victim in the case. Are you aware of that, Mr. Green?
Say that again, Your Honor. I probably.
And after he got to the jail, he started calling the victim immediately, and the magistrate was so he had to deny his phone privileges because of his repeated contact or attempted repeated contact with the victim in this case.
It's my understanding that the contact was simply for her to contact his parents because that was the only number that he knew. He actually lives in New Jersey.
Pardon?
I was saying he lived in New Jersey. His parents are in New Jersey, so he was calling her to contact his parents in Jersey, let him know that he was being locked up. But it was not of an assaultive nature at all, Your Honor. And certainly there was no.
Well, how long has he been in our state? Because I have a New Jersey address for him. I don't even have a Michigan address for him.
They live together in Michigan. Where do you live in Ann Arbor?
3617 Weeburn Court.
3617.
Weeburn Court.
How long has he been in the state?
About a year, Your Honor. A year. They were living together, boyfriend, girlfriend.
Well, I understand that, but I have a New Jersey address for him. I don't have a Michigan address for him.
That's
Number one. Number two, the other thing
3617
is,
Reburn Court, Your Honor.
pardon?
3617 Reburn Court.
Where the incident happened.
I guess the other aspect is that after, I mean, the comments that were made in this case, I think are a bit alarming. And then after being arrested, there's then contact with the victim in this case. And that is troublesome because I don't believe that, or at least leads the court to believe that if I were to release the defendant, that he would not be able to follow the court's orders regarding this.
Your Honor, if I may,
But there-
the address that is also being stated as the defendant's address is the victim's address and the occurrence of this, of where these events happened. So that just further exemplifies our concern for him returning and having additional contacts with the victim.
Your Honor, there was
Where
no,
would he go, Mr. Green? If he were released, where would he go?
Yeah, hotels, I can live with friends.
he's got friends here, Your Honor. He can go to a hotel. His
Well,
parents will put him up.
and, I mean, I may look at it again if there's an address that he goes to, but I'm disinclined to grant his release at this point.
But I'm just asking for a reduction, Your Honor, even a $20,000 10% bond, that's $2,000. That's a reasonable bond.
Well, I don't know
$100,000
that it's a
10% is
reasonable
unreasonable.
bond given the circumstances and the fact that I don't know that this defendant even resides really within this state, Mr. Green.
I
I mean,
understand.
that's part of my problem. I don't know where he will go. So at this time, he's coming back in a week. If I have additional information, I'll take a look at it again. But right now, motion for bond reductions denied. Bond will continue.
I'll get it to Your Honor. Thank you very much. Yeah.
Court calls case, People versus Dennis House.
Michigan.
County of Washington. Now in session. Judge J. Cedric Simpson.
The Honorable Judge J. Cedric Simpson preside.
Okay, it's been a long day. I don't know what happened. Don't even look at me. Can you state your name, sir?
John Torres.
All right. This is the date of the adjourned sentencing date. There was statements given by the mothers of the two young ladies to the court. They asked the court to look at additional information, which the 911 the recordings of the 911 were sent to the court. The court had reviewed them. Was there anything else from either side before the court goes into its decision? Anything from the people?
No, thank you, Your Honor.
Anything from the defense?
No, Judge, you've given us ample time. Thank you.
Let me just say that, and I guess there isn't an easy way for me to say this. And I guess, I don't know, I know the mothers gave their statements at the last hearing. I don't know, was there anything additional you wanted to tell the court? No, from neither, okay. There isn't an easy way for the court to say this, except for to say that, well, first of all, and I'll give everyone another opportunity to speak after I say what I'm going to say and what the court looks at, what the court has at least surmised. Defense's position is that certainly the defendant ought to be sentenced on the charge that he pled to. Much of that, frankly, I guess bears on the concept, or at least what has been said, that the defendant, Mr. Torres, was not in a position to see the accident. And that he was someplace else, which led to the plea. And again, it's not the court's province to get involved in what the particulars of the charge are, but to try to do its best to mete out a just sentence. Part of the reason also that the court had made a determination to at least hear the 911 tapes. I have a copy of the police report as well as Mr. Torres' statements. Was because I was going, and I said to the parents that there may not be anything that the court could do, but you were going to be heard by this court. And in doing that, some things, as I saw them, were a bit disturbing to me. And, you know, I'm not in, nor should I be, in a position necessarily to do some investigation to try to figure out what transpired entirely. But ultimately, the issue became, and I will make no bones about it, that if this court believed, despite the charges, that the defendant was indeed basically present when the vehicle went off the road and the accident occurred, that changes the court's perspective on what would be a proper sentence in this case. So initially, in listening to the 911 calls, particularly there were a few other calls, but I listened to Mr. Torres' call to 911. And that initially caused me some concern about whether or not the defendant saw this accident. And here's why. And again, I will give an opportunity to respond, but Mr. Torres initially contacts 911, and what was said to the court by Mr. Torres and what he had maintained to probation is that he didn't see this accident. I'm having a very difficult time believing that. And let me explain my reasons why. Defense counsel, I think, properly stated before that that Mr. Torres had called from someplace else. Mr. Torres contacts 911, and it's an odd call because of the way that I think the dispatcher was responding to Mr. Torres. But one of the things that was said is Mr. Torres put himself at First Street off of Superior. The dispatcher says that's not where we have you. Put a pin in that because that becomes important in the court's mind. At some point, Mr. Torres then says, I'm at First Street. He is then headed back to the location of the initial contact between the vehicles. Okay. All of that being said, I then review the police report and Mr. Torres' statements, and if everyone can recall, one of the things that the court was looking at was, did Mr. Torres chase these individuals and cause this accident? One of the things that was said in counter to that is that he's not near the accident, doesn't see the accident. Again, I'm having a difficult time believing that. And part of the reason I'm having a difficult time believing that is because there is an EMU security camera that's referred to in the police report that has these vehicles traveling down Huron River Drive, both at a high rate of speed, because Mr. Torres is in an Equinox, I do believe, and there's a truck. At some point, they get to the corner of Huron River Drive in Superior. According to Mr. Torres, it is a red light. The truck stops. He stops at some point. The truck continues through the red light. Mr. Torres indicates from the report, at least as I read it, that he then turns on a green light. Now, how that certainly all could happen. Bottom line is that they're then, Mr. Torres indicates in the police report that at some point on Superior, he disengages from, as he puts, following the vehicle. It's best the court's able to determine the distance from that corner of Superior where the turn is made to the railroad tracks. It's approximately 1,000 feet. Mr. Torres is then, if he is correct, and he is saying where he is to the dispatcher, this is where we take the pen out of that he's at first, but the dispatcher is saying, that's not where we have you. Mr. Torres is further up that road. But even if I give the defendant the benefit of the doubt that as far as he went was first, the railroad tracks are approximately 100 feet from that location. It is a clear shot from that location to see those railroad tracks and that intersection. It is not as though there is a crest. It is as though there is something that from first would obstruct one's view. The other thing that was specifically asked of Mr. Torres is he made it very clear that he did not go over the railroad tracks, but the additional thing that was asked is whether or not he crossed a bridge. Mr. Torres says he did not cross a bridge. That can't be true, because as you're going up Superior, to get to First, you have to cross the bridge. Moreover, when Mr. Torres is later questioned and talking to the dispatcher, he had to not only cross that bridge once, he had to cross it twice, because he had to go over the bridge and he had to come back to get to the location where it occurred.
I'll say something, Your Honor.
In a moment.
No,
No.
Moreover, when you listen to the other 911 calls that are called in, two vehicles that are traveling to the south, so they're traveling the opposite direction from the Getty's roundabout. They see the vehicle go in up, well, basically off the railroad tracks and have the accident. From really, and honestly, I mean, I don't know exactly where they are, but from putting again the defendant where he says he is, they are at a much further distance from those tracks than would be Mr. Torres. he's much further. Let me preface this by saying, through the other hearings, it was stated to the court that he is nowhere near the tracks and that he is further from the tracks where this occurred. That can't be true and everything else be true. It just can't be. He is within 100 feet, really between 80 to 100 feet of that intersection when that vehicle goes off the road. Certainly, and it also is perplexing from the court standpoint. I thought I understood it initially. When Mr. Torres is telling the dispatcher that he has the license plate of the other vehicle, one is thinking, or at least I was thinking, that he is getting that license plate by following the vehicle. That's not the case. He actually had the license plate of the vehicle prior to it turning onto Superior. Hence, realistically, there is no reason whatsoever for him to have continued. There is no reason whatsoever for him to have continued up Superior behind that truck. Now, if somebody, and counsel, I will give you an opportunity to address the court on that. And like I said, I'm not here, and I explained to Mom, it's not my province regarding the charge. My province is to mete out the sentence with what's in front of me. And again, I will give an opportunity for a response, but I can tell you where the court is at this point. The court at this point is of the opinion, and that Mr. Torres saw this happen. When he talks about the kicking up of dust and other things, the only place in that area that's going to happen is basically at those tracks. It's not going to happen on the turn off of Huron River Drive onto Superior. You're not paid. And, you know, and I'll just say it. When I look at all of this, I'm having a hard time believing that he's telling me the truth about this. Ms. Weidling, can you just put that GPS up?
Yes, I can.
Overhead.
Can I say something?
I'll let you, if your counsel believes that should speak, then I will let you speak, but
Are you ready for this?
I'm ready. Can you blow that up, or you're locked?
Do you need it closer?
Yeah, I just need it closer to the. That's good. Right. Yep, right there. At the very bottom of the screen, you're going to see the turn from Huron River Drive onto Superior. Up top of the screen. Sir, you will not disrupt these proceedings. I do not want to kick you out, but you are not going to disrupt these proceedings. Up at the top of the screen, you'll see
What starts as a routine courtroom hearing quickly takes an unexpected turn. A woman has already admitted to using cocaine and entered a guilty plea, seemingly hoping to move the case towards sentencing. But before she can leave the courtroom, another issue immediately grabs the judge's attention. The court discovers that she missed previous appearances, forcing a warrant to be issued. Now the judge wants answers. Where was she during all that time? The defendant explains that she was dealing with COVID, a hospital stay, a car accident, and even time spent in another county jail. But as the questioning continues, the explanation becomes more complicated. Then comes a statement that instantly changes the mood in the courtroom. The defendant admits she was recently riding in a vehicle that turned out to be stolen. That revelation appears to erase any sympathy she may have been building with the court. What happens next leaves the defendant frustrated, emotional, and completely caught off guard as the judge makes a decision she clearly was not expecting.
area traveling southbound on Superior. They see it. So again, I'm not here, I don't. I'm not here to worry about what's charged, what's not charged. I have to mete out the best sentence I can with what I have. And I will let you know, and counsel, I will give you an opportunity if you want to somehow or another speak with your client prior to the court imposing sentence. But I do believe that jail time is appropriate given what I see. I can't, in giving that, I can't bring back these young ladies. And I told the parents, I can't do that. But I certainly can do the best that I can to make sure something occurs. If I believed that Mr. Torres was not present, that it was as it was portrayed to this court, a circumstance where he could not have seen it, that he would have been so far down on Superior that he wouldn't have seen the railroad tracks, then that's where I would land. And I would have no problem landing with that and justifying it. I can't, based upon his own statements, justify that as being true. He had to see it. He's telling me he's 2 to 3 cars behind them, that he's following them, and that he's at first, and it's a clear shot to those railroad tracks. If somebody wants to tell me how I can come to a different conclusion, then please tell me that. But I can take into account in terms of sentencing whether or not a defendant is being truthful with the court in terms of what they're saying. And I will be blunt. I'm just a plain talker. I don't believe that he is. Counsel, if prior to Mr. Torres is, I don't know that you can see him or not, he really wants to make a statement, I will arrange, counsel, I know you don't want him to. If you want, because since you're not here, if you want to talk to him, I will arrange to get him on a Zoom and get you guys into a breakout room so you can talk.
No, Judge, that's fine. I'm ready to make a comment when you're ready to hear it. I don't need.
Oh, go ahead. Sir.
Judge, with all due respect, this is wildly inappropriate. For you to be doing an investigation on your own, for you to be pulling up.
Counsel,
go ahead, Judge. You're the boss.
Counsel,
Yes, Judge.
Stop a moment. I think I acknowledged that. I'm not here doing an investigation. The question is what was represented to this court is that he could not have seen it, that he was not following them. Anything that I have here is not an investigation. All I did was listen to the 911 and read the police report. So in that case, if you think that's inappropriate, then fine, you can go ahead with your statement. And then I will proceed to my sentence.
Right. In addition, Judge, you pulled up a map and you said that it's impossible to see, or that it's possible to see where the accident was without actually being at the scene viewing it. There was no trial. There was no any opportunity for the defense to present you with counter evidence or anything like that, Judge.
Counsel, what do you want to give me? What do you want to give me?
I don't want to give you anything.
What do you want to give me? No, Judge, counsel, if you're going to say I'm being unfair, what do you want to give me?
Judge, I want to tell you that I don't believe you should be considering anything that will occur after that.
What you represented to this court, and I realize you're advocating for your client about him being someplace further from that scene, it's not true. It's his own statements. These are not anything where I went out there and I'm looking at something or I'm doing whatever. It's just placement. He's saying he's at first. I just listened to the tape. I didn't do anything. I didn't go out there and investigate, talk to any witnesses, do anything like that. I did that and looked at a map. That's all I did.
Right, Judge.
So if you want to give me something, counsel, you can come here 2 hours late. Give me what you want to give me.
Judge, I don't believe you should be considering anything after the fact of the initial accident. He's being sentenced for failure to stop at a PD accident. It has nothing to do with what he did afterwards. It's completely inappropriate for the court to be.
What he did afterwards?
After the accident, when he was initially rear-ended, that's what he pled to, failing to stop at that accident. It's not failing to stop at the accident that the girls were involved in. It's failure to stop at the accident where he was rear-ended. Ms. Reiser agrees.
If your client, knowing what I'm going to do, wishes to withdraw his plea, I will consider that motion.
Judge, I would also ask that you recuse yourself at this point.
Denied.
Understood. And I can, if you wouldn't mind allowing me to speak with Mr. Torres, my guess is he's going to withdraw his plea.
I'm sorry?
If you wouldn't mind allowing me to speak with Mr. Torres to make sure this is going to happen, but my guess is he will withdraw his plea.
Can we set up a breakout room for Mr. Torres in signing on to Zoom in one of the conference rooms? Mr. Torres, we're going to put you into one of the conference rooms out there. We're going to put that machine into a breakout room and put your counsel into a breakout room so you guys can talk. Court will stand in recess. We're back on the record in the Torres matter. Had an opportunity, well, first of all, that counsel had an opportunity to speak with his client. It's been also an opportunity for the court to speak with counsel.
Now, the focus shifts to a completely different defendant, but the legal issues become even more serious. This man is asking the court for a lower bond, arguing that he has no criminal history and should not be held on such a high amount. On the surface, that sounds like a reasonable request, but prosecutors point to something much more concerning than a clean record. They describe allegations involving an ex-girlfriend, a confrontation at her residence, and statements that suggest the situation may not be over. Even more trouble for the court are claims that the defendant continued trying to contact the alleged victim after his arrest. At this stage, the judge is weighing more than just the original allegations. The court is looking at risk factors, whether the defendant might return to the same location, whether he can follow court orders, and whether he even has a stable place to stay if released. As those questions pile up, it becomes increasingly clear that the judge's biggest concern is public safety. And that concern is about to determine whether this defendant walks free or remains behind bars while the case moves forward.